Very pleased to be joined by Mark Dubbery, barrister and mediator at Pump Court Chambers. Mark, somebody wishes to challenge a will. They feel they've been treated unjustly, unfairly, and they haven't received their fair share of the estate. What can they do?
It rather depends what you mean by their fair share. If they are entitled to money pursuant to the provisions of the will, and it's just a case that the executor or administrator is being a bit slow in sorting things out, then they can write to them and ask what the problem is, and if they still don't get a satisfactory response, they can make an application to have them removed or replaced by somebody else. If, on the other hand, the will makes provision for them which they consider unfair, then that's a slightly more complicated process, and that may well involve an application under what's called the Inheritance Provision for Family and Dependents Act. And that's a case of going before a judge and persuading the court that reasonable financial provision hasn't been made for that person, but it has to involve provision for their maintenance, unless they're the spouse or civil partner of the deceased. In other cases still, it may be the case that the belief is that reasonable provision hasn't been made because undue pressure has been put upon the testator or testatrix, or perhaps that they were not in their right mind when they made it, they didn't have the mental capacity to make it, and that involves a third type of proceedings known as probate proceedings.
That's tremendous. Thank you very much, Mark. Thank you.